Hello everyone, this is Louis. Welcome to the channel. This is your first time here. Thank you for checking us out. The purpose of this channel is to share some good and important information with you, and hopefully this will give you some positive energy to enjoy your day. Now, today I would like to share some of the important changes that happened in 2022 to the Succession Law Reform Act and also the Substitute Decisions Act that may affect people who are married, separated, or in a common law relationship. You should be aware of all these changes and seek proper advice to ensure your testamentary documents are in full compliance with the change. There are about 5 important changes that you should be aware of. The first one is called virtual meetings. Before 2022, wills must be signed in person and in ink in front of 2 witnesses. The new changes will now allow wills to be signed and witnessed virtually via internet. During the pandemic, this is when the rule was changed, and now it applies to all the wills made on or after April 7, 2020. This virtual method requires all participants must be able to see, to hear, and to communicate with each other in real time. And also, at least one of the participants who acts as a witness must be a licensed lawyer or paralegal. The testator, which is you, and the witnesses must sign at the same time, and it does not permit electronic signatures. Therefore, signing your will in ink is still a requirement for a will to be valid. Now, this amendment also allows virtual witnessing for the power of attorney documents. Now, here's the second change. If you got married before January 2022, the marriage would have canceled all of the will that was not made in the contemplation of the marriage. However, after January 1, 2022, marriage no longer cancels any existing will. However, this rule does not apply retroactively. Now, here's another important change. Before the new laws, a separated but not divorced spouse remained entitled to share in an estate as if they were named in the will. But now, with the new law, spouses who have been separated but not yet divorced for at least 3 years before a death occurs after December 31st, 2021, or immediately preceding the death, had a valid separation agreement, are treated the same as the divorced spouse. Now, also, if the deceased has no will at the time of death and was separated from his or her spouse, then the spousal entitlement will no longer apply. However, the change doesn't affect beneficiary designation on life insurance policy and registered plans. Therefore, if you are divorced, make sure you change the beneficiary on your insurance policies and any registered plans such as your RSP or your RIF. Another point is the intestacy provision will no longer apply to a separated spouse, which means spousal entitlement will no longer apply when there is no valid will. Now, here's point number 4. Before the new laws came into effect, the court has no power to determine whether a document is a legal will or not. But now, courts can validate wills that are not executed properly, provided the court is satisfied that the documents set out the testamentary intentions of the deceased. Now, when a will is deemed invalid, then the estate property is distributed according to the intestacy rule in the Province Estate Act. Now, here's another important point for you to remember. In recent years, a lot of financial institutions recognize electronic signature as a legal signature. However, it is important for you to understand the new law still does not allow the court to declare a document or writing as a valid will if it bears an electronic signature. So please make sure you do not do electronic signature on a will or a power of attorney. Well, that's all for today. I hope you find the information useful. And if you enjoyed the video, please give us a thumbs up and subscribe. Now, I want to remind you that the information provided here is for information and discussion purposes only, and should not be considered as legal, accounting, or investment advice. You should always consult your own legal professionals for more information. Well, I thank you for sharing your time with us today, and I look forward to seeing you again soon in the next episode. Goodbye.